Hello and welcome to the 17th lecture in this lecture series introducing international arbitration practice. In the 15th lecture, we drafted an international arbitration clause from scratch. In the 16th lecture, we made that clause a multi-tiered one. In this lecture, we will use the same clause to modify it so as to include the accepted matters clause. To do this, we devote a separate subclause for accepted matters. This will first entail adding a phrase except dispute stated in subclause 2 of this clause. So we add that. So we highlight the changes so that it is apparent to you what changes we have made in this lecture. Right. Now, the next thing that we do is we add that subclause. The new subclause would state the following matters shall not be resolved by mediation or arbitration as per this clause, and the decision of the engineer shall be final and binding on the parties. Liability and quantum of liquidated damages payable. And the second matter that we accept, that is exclude out of mediation and arbitration, is quantum of extension of time for completion of contract. Thus, two things are being done here. First, certain disputes are being excluded from the scope of mediation and arbitration. And two, for those excluded matters, the decision of the engineer is regarded as final and binding on the parties. Note that since arbitration follows mediation, it is simply enough to exclude those accepted matters from mediation. But as a matter of abundant caution, it would be useful to mention the exclusion from arbitration explicitly. To do that, we include the phrase that we previously included in subclause 1 in subclause 3 as well. So we simply paste it here. And we highlight subclause 2 also because that is a recent addition. The language of the determination of expert is usually taken care of by the language of the contract clause. But if you want to include it here, please feel free. In that case, subclause 4 will now read, after inclusion of the phrase so this clause will now read, the language of the engineer's determination, mediation and arbitration shall be English. We need not have this the. Please recollect that in the previous lectures we made a checklist for arbitration clauses. That was a 23 item checklist. Now we'll see if this clause that was drafted from scratch covers those items mentioned in the checklist. The checklist is available in the link provided in the description to this video. You can have a look at it and access it and even download it. Now, for the first item, it says whether all disputes arising out of or in relation to this agreement is sought to be referred to arbitration. Predominantly yes, except for subclause 2 before you. Whether any pre-arbitration procedure is to be followed, and if so, what? Yes, pre-arbitration procedure is to be followed, and that is mediation. And before that, certain disputes are accepted or excluded from the scope of the dispute resolution clause. Whether the pre-arbitral procedure is for a designated period. Yes, the pre-arbitral procedure of mediation is for a specific designated period, and the engineer's determination takes its own course. Now, we have a typo here, except as per this clause. Yeah. But if you want the expert to determine within a specific period, you can also provide that in the clause. Here, then we add one more provision: the engineer shall make his decision or determination within 3 months from the date when the issue is referred. Alternatively, since this is a part of the contract management related issue, you can have a slightly open-ended obligation saying that the engineer will make his determination within reasonable time, but not exceeding 3 months. So there are various permutation and combinations available. Nothing wrong in having a specific time limit for determination by the expert. How will the pre-arbitral procedure be triggered? So the pre-arbitral procedure will be triggered by a reference to mediation. And that is provided here in subclause 3, which talks about within 3 months from the date of reference to mediation. Then, how will the pre-arbitral procedure terminate? The pre-arbitral procedure will terminate by either resolution of the dispute through mediation and signature of the settlement agreement, or by failure of the mediation, or by the expiry of the 3-month period. So that is also provided in subclause 3. On termination of the pre-arbitral procedure, how will arbitration get triggered? The arbitration is usually triggered through an arbitration notice when the dispute resolution through mediation fails. So that is provided in the relevant arbitration rules. In this case, Singapore International Arbitration Center. So we need not worry about it because that is covered in the rules itself. Whether certain matters would be excluded from the scope of the arbitration clause? Yes. Those exceptions are provided in subsection 2, and references are made to those exceptions in subsections 1 and subsection 3, subclause 3. Whether certain matters would be excluded? Yes. Whether the excluded matters are listed out comprehensively in the dispute resolution clause? Yes. That is provided in subclause 2. Whether parties wish to provide for specific dispute resolution methods for those excluded matters? Yes, we have provided for determination by the engineer. To make this clause more certain, rather than decision, we can call it determination. Okay. Whether parties wish to provide for arbitration in case parties or any of them are not satisfied with the decision? No. Expert determination, once done, is final and binding on the parties, and there is no arbitration provided for. Whether the agreement provides for resolution of an entire class of disputes through one forum rather than splitting of class of disputes? Yes. So it is very restrictive in terms of expert determination. Liability and quantum of liquidated damages payable is covered by the expert determination, and the quantum of extension of time for completion of contract. Then, what is the law of arbitration agreement, and has it been spelled out explicitly? We have not provided for the law of arbitration agreement explicitly here, and that is covered by the choice of law clause, so we will discuss that later. Then, whether the arbitration clause should provide for institutional or ad hoc arbitration? Yes, it provides for institutional arbitration here. So it will be covered by the number of arbitrators, process of appointment of arbitrators, the appointing authority, and all these would be covered by the relevant rules, which is SIAC rules here. Where will be the seat of or place of arbitration? We have specified that in subclause 1 as Singapore for mediation, and add Singapore we have provided in subclause 3 for arbitration. Whether the proceedings could be heard in venue other than the seat of arbitration, that is covered in the relevant institutional rules. We need not worry about it. Whether the contract provides for a choice of language clause. Yes, it provides for the choice of language clause, and that is covered for all the three dispute resolution processes here: engineer's determination, mediation, and arbitration. So that covers a 23 item checklist. Note the usefulness of the checklist. Although we predominantly completed this clause before us, still having a perusal of the checklist made us tweak or fine tune the dispute resolution clause. So that is the advantage of using checklists. That's all in this lecture. In the next lecture, we would be covering other aspects of drafting arbitration agreements. But with this, we complete our series of lectures on drafting arbitration clauses. That's all. Have a great day. Bye bye.